the Constitution requires that the people choose their judges. If somebody dies tonight, that vacancy is supposed to be filled by the people at the next biennial election occurring more than 30 days after the death. Instead, what happens is, under the statute, the governor appoints in direct violation of the Constitution. And so the problem is, admittedly, wrongfully, criminally, or just negligently, they're all involved in it. The governor's office, the legislature, and the Supreme Court of Appeals have a conspiracy to keep retention elections because they, I think, sincerely think that the appointment of judges is a better proposition, better way to get judges than the election of judges. And they may be right about that, but the Constitution says they shall be elected, and so when the governor and the legislature and the judges go along with the appointment, they are thumbing their nose at the Constitution. And so I have regarded it as my duty as a sort of a public citizen. I've been twice the Democratic nominee for governor, and I'm a lawyer. And sort of as a public citizen, I have regarded it as my duty. As a lawyer, you have a duty you swear that to the best of my skill and ability, I will honor the Constitution, so help me God. And I've tried to do that in the context of this circumstance about retention elections. And the fight's been going on, as I've said, since 1996, still goes on. Now it's before these special judges. These special judges were picked by the governor. Now the question is, are these special judges competent to hear this case? That is, are they disqualified because of some interest that they may have? And one of the judges he's picked is the former Chief Justice of the Supreme Court, who was retention elected and who's still drawing he's retired, still drawing his pension under the retention election statute. How can he possibly be neutral or impartial into this decision? Nonetheless, he's been picked by the governor to be one of these judges, and I'll have my say about that when the judges meet here in Nashville to decide this case.
So you're saying that because he gets a paycheck from the state from his time being on the Supreme Court, that is what
he's got an economic interest in the subject matter of the case. If the retention election statute is unconstitutional, he's not entitled to take the taxpayers' money and pay himself a retirement. And he wasn't entitled to take the taxpayers' money and pay himself a salary, which he did all those years. And what's the chance of him saying, oh, I was wrong about that, I shouldn't have taken that money all those years? The statute is really unconstitutional. Hell will freeze over before he says that. And consequently, he's not competent to sit on this case. If I win my case, Hooker versus Haslam, and the special court decides that they are unconstitutional seated, the first thing is they got to step down. You can bet this, it was a sour day for them the day they stepped down to the extent of recusing themselves and turned their destiny over to this special Supreme Court who has the right to say whether or not they're constitutionally seated or not constitutionally seated. And that day is coming upon us soon. This is like, you're too young to remember a movie called 12 O'Clock High. But this is going to be a shootout in the Supreme Court chamber, a shootout in the sense of a legal contest between lawyers and refereed by the judges to determine whether or not this act is constitutional or not. I happen to be the great-great-great-grandson of the man who drew the Tennessee Constitution, who was the president of the Constitution, and my son's named after him. His name was William Blount, and he was the architect of the Constitution. Then I had another ancestor who was in the Constitutional Convention of 1870. His name was Henry Williamson from Wilson County, and he presided over the debate about whether or not we should copycat the federal system and have the executive appoint the judges, or whether they should be elected by the qualified voters of the state. And after 3 days of debate, they said they'd be elected by the qualified voters of the state. So I sit in this chair today, all those years later, 116 years after Blount, and all those years since 1970 after my other ancestor, still fighting for the right of the people to elect their judges, to choose them. That's what democracy is all about.
So secretly you don't have some sort of preference of what you'd like to see it done? Like some sort of combination of the
I think there are good arguments that you can appoint judges, that federal judges have been appointed. I think the better argument, and when I vote, I'm going to be on the side of the people electing the vote. The genius of democracy. Martin Luther King happened to be a friend of mine, and I liked him. He helped me when I ran for governor, and I got 96% of the minority vote in this state, standing up for civil rights. I was a civil righter then, I'm a civil righter now. And the right to vote is a civil right, and so I'm always in favor of the right to vote and to have a choice, so that the people are the monarch, the people are the boss, not some politician who appoints judges.